Thank you, Celeste. Les premières années et l'adolescence de Giuseppe Joe Ortona prend racine dans les écoles de la commission scolaire English Montreal, dont il est maintenant président. Ayant grandi à Saint-Léonard, il a fréquenté l'école primaire Nesbitt avant d'obtenir son diplôme d'études secondaires au collège Vincent Massey en 1998. Massey? Massey. I'm trying to say it in French. Massey. Ça marche pas. Massey. Le parcours scolaire de M. Ortona est impressionnant. Il a suivi un programme de technique policière au collège John Abbott, a étudié la criminologie à l'Université de Montréal, puis a obtenu un doctorat en droit civil et en common law à l'Université d'Ottawa. Il a ensuite été procuré pour la ville de Montréal pendant 5 ans. Il travaille maintenant comme avocat de la défense aux criminels dans son propre cabinet. Il a d'abord rempli un rôle de gouvernance à l'EMSB lorsqu'il est présenté comme commissaire dans Rivière-des-Prairies. Il a été élu en 2014. Il a occupé ce poste pendant 6 ans et en 2018, il a également occupé le poste de vice-président. En tant que représentant du Conseil, M. Ortona s'est occupé des questions législatives au fil des ans, notamment dans les domaines de la gouvernance des commissions scolaires. Il a fait campagne contre le projet de loi 40 du Québec, de la loi 21 et a réussi à faire échouer le projet de loi 86. Giuseppe Joe Ortona's early and teenage years of education are rooted in the schools served by the English Montreal School Board, of which he is now president. Growing up in St. Leonard, he attended Nesbitt Elementary School before graduating from high school at Vincent Massey College in 1998. Mr. Ortona's educational path is quite impressive. From completing a police technic program at John Abbott College to studying criminology at the University of Montreal, and then completing his Juris Doctor at the University of Ottawa in civil law and common law. He then served as a prosecutor for the City of Montreal for 5 years. He now works as a criminal defense attorney at his own law firm. He first fulfilled a governance role at the English Montreal School Board when he ran for commissioner in Rivière-des-Prairies and was elected in 2014. He held the position for 6 years, and in 2018 he also served as vice president. As a council representative, Mr. Ortona has dealt with legislative matters over the years, particularly in the area of school board governance. He campaigned against Quebec's Bill 40, 21, and defeated Bill 86. Please put your hands together for a warm welcome for Joe Ortona.
It's difficult for me to talk about Bill 96 without touching upon Bills 21 and Bill 40, and I'll explain a little later how that all ties in. At the English Montreal School Board, we've been opposed to Bill 96 since it was announced. We've made our intentions clear that we did not agree with this bill. This bill, I think, contradicts our values, our shared values as Montrealers, as members of the English-speaking community of Quebec, as Quebecers, as Canadians, values of diversity, tolerance, acceptance, multiculturalism. The idea that if you've been here for longer than 6 months and you still don't speak the French language, that you're still welcome here. We actually launched the court challenge. We announced officially and voted at the English Montreal School Board that we were going to challenge Bill 96 2 days after it was adopted. So we were the first group to do so. We actually filed our Bill 96 challenge on the day that the Lieutenant Governor gave it royal assent, so on the day that it took effect. And the bill has some great consequences in the field of education. Think of our English schools, which really are bilingual schools if you think about it. All of our schools, or almost all of our schools, either follow bilingual curriculum or a French immersion program, which is not due to Bill 101. We've had in our English system a French immersion program since the 1960s. So we've learned as a minority community to integrate Quebec society way before it was imposed on us with Bill 101, because Bill 101 was passed in 1977. So we were 2 decades ahead of the PQ government at the time. But because of Bill 96, our English schools now require that all communication between staff members be in French or in French and English. The irony of that is if it takes you 20 minutes to write an email to a colleague, you're not going to spend 40 minutes to write it in 2 languages. So it's really a veiled form of, trying to dissuade the use of English. So principals have to speak to their staff in French in an English school. Anything that is non-pedagogical in nature has to take place and occur in French. So we've been very clear about that from the beginning. That's a violation of Section 23 of the Canadian Charter of Rights and Freedoms. Section 23 is, it's what we call the language of instruction clause, where the linguistic minority has the constitutional guarantee to be allowed to send their children to the minority school of the province, but it's way more than that. It's also a right to manage and control its own school system. And one of our meetings in the month of March, actually, one of our public meetings at the English Montreal School Board, I spoke at length about some of the provisions that Bill 96 suspends, because it's too bad that the media isn't here tonight, because I would have highlighted that they've done a really poor job about talking about Bill 96 and its consequences. Because Bill 96, they talk about the use of the notwithstanding clause. Well, what is the notwithstanding clause and what does it do? So you can't use the notwithstanding clause for just anything. There are specific constitutional rights, however, that the notwithstanding clause can suspend. And those are specifically sections 2 and 7 to 15 of the Canadian Charter of Rights and Freedoms, and sections 1 to 38 of the Quebec Charter of Human Rights and Freedoms. So it basically suspends about 48 guaranteed rights. And the irony is that, they talk about the Canadian Charter having been imposed on Quebec society because Quebec never signed the Constitution. But the Quebec Charter of Human Rights and Freedoms was adopted unanimously by the National Assembly in 1975. And that's a full 7 years before the Canadian Charter ever even came to existence. And so this was adopted by the provincially elected officials elected by the people of Quebec. And so this government felt that these provisions should be suspended. And unfortunately, the only one that really got reported about sometimes in the media was this unlawful search and seizure. That the OQLF can simply, go into a place of business and without a warrant seize computers, phones, any technological devices and things like that. Which is true, by the way, because that protection that is in the Charter has been suspended. And of course, I think it was somebody from the CAC, it was probably Christopher Skeet, who said, well, of course, we trust that the OQLF, they're going to use their better judgment and they're not going to do that. I personally wouldn't trust the same morons who are responsible for Pastigate, and I wouldn't rely on their judgment. So, just want to go through, and I did this in one of my meetings at the EMSP. I went through some of the provisions that are suspended, some of which touch upon healthcare. And so, of course, we've heard the government say over and over again that nothing is going to change regarding access to healthcare for the English-speaking community. Of course, I don't know why Bill 96 would be necessary if it doesn't do anything. So it's obviously doing something. So, just going to go through some of the rights here that Bill 96 suspends. Every human being whose life is in peril has a right to assistance. I don't know why the government felt the need, if healthcare isn't affected, why they would suspend somebody from having that right. So, every person has a right to the safeguard of his dignity, honor, and reputation. So they've suspended that right. Every person has a right to respect for his private life. They've suspended your privacy. A person's home is inviolable. So I guess your home is violable now, and not just your place of business. No one may enter upon the property of another or take anything therefrom without his express or implied consent. So they can take your stuff, whether you agree to it or whether you don't. Every person has a right to non-disclosure of confidential information. That's a right that they've suspended, that Bill 96 suspends. No person bound to professional secrecy by law may, even in judicial proceedings, disclose confidential information revealed to him by reason of his position or profession. So doctor-patient privilege is no longer a protection. Attorney-client privilege is no longer a protection. Every person has a right to petition the National Assembly for the redress of grievances. That's a right that they've suspended, although they haven't listened to us for the last 3.5 years, so I don't think that one really makes a difference. Let's look at some of our judicial rights that they've suspended. Every person has a right to a full and equal public and fair hearing by an independent and impartial tribunal for the determination of his rights and obligations or of the merits of any charge brought against him. That's a right that they've suspended. You no longer have, for the purposes of Bill 96, the right to a fair trial. No one may be deprived of his liberty or of his rights except on grounds provided by law and in accordance with prescribed procedure. That's been suspended. No one may be subjected to unreasonable search or seizure. That's been suspended. No person arrested or every person arrested or detained must be treated with humanity and with the respect due to the human person. I guess they can torture you now. Every person confined to a correctional facility has the right to separate treatment appropriate to his sex, his age, and his physical or mental condition. That's a right that Bill 96 suspends. Every person confined to a correctional facility while awaiting the outcome of his trial has the right to be kept apart until final judgment from prisoners serving sentence. You don't even get the benefit to be presumed innocent. Every person arrested or detained has a right to be promptly informed in a language he understands of the grounds of his arrest or detention. So they don't have to tell you. They don't even have to tell you why. Every person arrested or detained has a right to immediately advise his next of kin thereof and to have recourse to the assistance of an advocate. He has a right to be informed promptly of those rights. Those are rights that people who are arrested for crimes have, by the way. People who are arrested for criminal offenses have these rights. Anglophones don't have them now when it comes to the OQLF. Every person arrested or detained must be brought promptly before the competent tribunal or released. They've suspended that right. Every accused person has a right to be tried within a reasonable time. That's a right people who are charged with criminal offenses have. And you hear it sometimes in the media when cases are dropped because of unreasonable delays. That's a right that's been suspended by Bill 96. Every accused person is presumed innocent until proven guilty according to law. Presumption of innocence is no longer a protection in our penal justice system. No accused person may be compelled to testify against himself at his trial. They've suspended that. Every person has a right to be represented by an advocate or to be assisted by one before any tribunal. They can deny you your right to an attorney. Every accused person has a right to a full and complete defense and has the right to examine and cross-examine witnesses. You don't even have the right to a full defense. You don't even have the right to cross-examine the reliability or credibility of the witnesses that testify against you. Every accused person has a right to be assisted free of charge by an interpreter if he does not understand the language used at the hearing or if he's deaf. You're not entitled to a fair trial. You're not entitled to a full defense. You're not entitled to be aware of the charges. You're not even entitled to understand what's happening anymore. No person may be tried again for an offense of which he has been acquitted or of which he has been found guilty by judgment that has required status of res judicata. You no longer even have the protection from double jeopardy anymore. You can be tried again and again and again and again for the same offense. And if you're acquitted, the government can decide, we don't care. I'm going to try you again. So naturally, when I read some of these, and I went through others, there's more of them in here actually. My Council of Commissioners was quite outraged by that. And so there was not unanimous, but overwhelming support against Bill 96. And so these are the reasons why we're taking this to court. And we were the first ones to launch, and I'm very proud of that. And these are the same rights, by the way, all of the ones I've read and others, that are also suspended by way of Bill 21. Bill 21 is the religious symbols ban, which we've also challenged at the English Montreal School Board in court. And I'm proud to say successfully, because we got a partial win on that, albeit a partial win, because we challenged Bill 21 on two grounds. Obviously, we challenged it to have the law struck down in its entirety as unconstitutional, but we also challenged it as it comes to English language school boards and the infringement of our right to manage and control our system, because it restricts our ability to hire the teachers that we want. And on that ground, we won. And so the Bill 21 was declared unconstitutional for English school boards. The government is appealing that decision, and that's going to be heard sometime in November, I believe, and we're probably going to get a decision next year in the spring. But I'm confident that that's going to be upheld, and in fact, we're appealing the fact that we lost to have the law struck down in its entirety, and I'm somewhat confident that we may win in that regard. And no matter what happens there, I'm sure that that's something that we're going to find, that will find itself before the Supreme Court. Of course, I don't need to tell you about Bill 21 and all of the values that, how it goes against our values. I mean, I'd be repeating myself. Everything that I said before about diversity, acceptance, religious diversity, linguistic diversity, those are all things that we accept here in Quebec, or at least, we used to. Because the truth is, I grew up, I grew up with the PQ government in power for many years, and I remember them even though I wasn't old enough to vote. I remember their policies and I remember their politics quite well. But we have never had, as far as I can remember, a government in Quebec that is so hostile toward English-speaking Quebecers, religious minorities, and just minorities in general. They won't even recognize that systemic racism is actually a thing here in Quebec, which is an offense in and of itself. And so I'm proud that we're challenging these laws before the courts, and I'm confident that we'll win. But I think the important thing to highlight is how we're even possible to challenge these laws, because the government tried in 2019 to abolish school boards altogether, and they transformed school boards into service centers. And we were able to successfully get an injunction to block the application of the law as it pertains to English language school boards, again on Section 23 rights. So those Section 23 rights are really coming through for us, the linguistic minority community in Quebec. And without that, we would not have had the independence to challenge Bill 21 as an elected council, and we would not have had the independence to challenge Bill 96 as an elected council. And of course, we're waiting for a judgment on the actual merits of the case. The case has been heard quite some time ago. We're still waiting for a decision, but until we get a decision, the injunction is in place and we continue to operate as a school board. And I just felt it was important to highlight some of these things that are in our Quebec Charter of Human Rights and Freedoms that nobody in the media really spoke about. Other than the warrantless searches, nobody spoke about how this bill actually affects people every day. It has real consequences. And unfortunately, those consequences are going to be seen after the bill takes effect. But by then, it's too late. By then, it will have passed, and people become more complacent. And we haven't seen a whole lot of leadership really against Bill 96 from our elected officials. At the federal level, they've been very quiet. They've been very hesitant to even speak out about it. The federal government has said that they will only get involved once it gets to the Supreme Court. The federal government has the power right now to reference the law to the Supreme Court and save us all of the years of court challenges, save us the time and money, and they can go to the Supreme Court and ask them right now and say, does this law respect the Canadian Constitution?
Why don't they?
Because Trudeau has no
Why don't they? Because Trudeau's incompetent.
Well, I'll answer the question, why don't they? I mean, this is my personal opinion. I don't speak to Justin Trudeau personally. But politicians make decisions based on what they feel is the will of the majority. And what they think, they make their decisions, basically, there's a lot of political influence. Politicians will not make decisions if they think, politicians will not make decisions, certain decisions if they think that it will hurt them politically, which is why I have more faith in the justice system and the courts than I do in the elected officials, because the judges will not make decisions based on what they think is popular. The judges are not afraid to make controversial decisions if that's what the law says, or that's how the Constitution says a certain law should be applied, and they don't have to worry about angering people and hurting their chances of being reelected, because they're not elected, they're appointed. So I just wanted to highlight some of these things and speak about that and just say that I'm proud to be leading the charge for these challenges, and I'm obviously very happy that we still at the English Montreal School Board are a school board and that we're allowed to exist, because without that we wouldn't have the independence to be bringing this forward. And thus far, when it comes to Bill 96, other than the English Montreal School Board and a handful of lawyers who are challenging this bill, there isn't anybody else that has stepped up to the plate to challenge this in court. And so there's a real possibility that none of this would be challenged if we weren't allowed to exist as a school board. So I take our Section 23 rights very, very seriously, our right to manage and control our school system, and because of that, I will always fight for those rights. And whenever those rights are violated in any way, by the government, whatever the cost, or whatever the time it takes, they're worth fighting, because if you lose those rights, you're not going to get them back. And so it's important, and I want to thank everybody for being here tonight, because if you're here tonight, it's because you're a fighter, and it's because you want to fight this bill, and you want to see this bill struck down. And of course, I want to see this bill struck down, and I'm confident it will be. Otherwise, I wouldn't be going through the trouble of challenging it. And so I want to thank you all for your time. I want to thank you all for giving me the opportunity to speak, and we're going to keep fighting. We're going to keep going at it. And as I said, I'm confident that we'll win, and then hopefully we'll be able to celebrate that and turn the page for what I think is a pretty dark period in our history, and I think that history in the future will look at this period in that way. So thank you very much.